please. Ms Adamson.
Thank you very much, Presiding Officer. May I first thank my committee clerks, our advisers and all those who gave evidence and submissions to our inquiry for their interest and support. Presiding Officer, there shall be a Scottish Parliament. 6 simple words, but almost exactly 24 years ago, the Scotland Act, the statutory underpinning of our Scottish Parliament, became law. First lines of legislation are seldom memorable, but I would suggest that this is the exception. The most recent Scotland Act, enacted in 2016, was intended, in the words of Prime Minister David Cameron, to deliver one of the most powerful devolved parliaments in the world. However, the impact of Brexit, as well as UK legislation following the UK's withdrawal from Europe, cannot be overstated. Presiding Officer, the conventions which underpin devolution are coming under strain. This was the key message from our inquiry. A report into the impact of Brexit and devolution was informed by evidence sessions themed on legislative consent, being the means by which the devolved legislature indicates that its content for the UK Parliament to pass law on a devolved area. The UK-EU Trade and Cooperation Agreement, the TCA, implementation of the Protocol on Ireland-Northern Ireland, and retained EU law, a bill that is currently passing through the Commons. And, of course, intergovernmental relations, which runs through all of these topics. We chose to focus on 3 areas: regulatory divergence, the Sewell Convention and delegated powers, which my Deputy Convener will cover in his summing up. While technical in nature, our report is about how we legislate and what we regulate. There are implications for our everyday lives, including in how we do business, how we protect the environment and how we ensure the safety of both the products on our shelves and the food on our plates. Our earlier report, published in February, highlighted the tension that can exist between open trade and regulatory divergence. In this report, we looked at the extent to which regulatory divergence is limited both within the UK internal market and between the UK internal market and the EU single market. We addressed the possibility of different policy and legislative priorities within the 4 nations of the UK and the extent to which devolution needs to evolve to allow for that. When the UK was a member of the EU, options for divergence within the UK in devolved policy areas within EU competence were minimal. The statutory obligation was on the UK to comply with EU law. Now, of course, that obligation no longer applies, except in the case of Northern Ireland, although the Protocol Bill currently being passed through the UK Parliament may change that too. We should also note that the policy of both the Scottish Government and the Welsh Government is to keep pace with Europe. It is now possible for a much higher level of regulatory divergence both within the 4 parts of the UK and between the UK and the EU. There are, though, commitments to non-regression in environmental standards, labour rights and social responsibility in the TCA. And in this way, the TCA seeks to establish a level playing field between the EU and the UK on trade and investment. However, it is important to note that divergence is allowed under the TCA. Professor Catherine Barnard spoke of active and passive divergences. The former can arise from a deliberate policy choice, the latter due to EU-level decisions that the UK no longer needs to follow. However, our businesses must comply with EU law to be able to sell into Europe. And we don't know the extent to which non-regression principle and the level playing field provisions might therefore limit regulatory divergence. The Northern Irish... Yes, we'll take it.
Willie Rennie.
I'm listening carefully to what she's saying. Did the committee come up with any actual examples of practical divergence that's causing harm right now? Because I can't really find any great examples of this. The whole exercise seems to be rather futile.
I would suggest not, Mr Rennie, but in terms of the examples, they were in the evidence that was given to the committee, and I would refer him to that evidence. And also the fact that this is an extremely fast-moving situation, and almost as we are looking at these issues, other things come on the table, like the Northern Irish Protocol Bill. So I think it's a technical bill, but it does lay out the challenges that may face us ahead in this situation. The Northern Irish Protocol negotiated in Brexit settlement is a further complicating factor. Dr Lisa Claire Whitten told us the UK must keep Northern Ireland aligned with any changes made in the EU legal instruments included within the scope of the protocol. This has been described as dynamic alignment. To date, this has involved 300 instruments and suggests UK-EU divergence, leading in time to divergence between the Northern Ireland and the rest of the UK. The fundamental question being asked is the extent to which devolution settlement can accommodate this divergence. Dr Whitten suggests the Scottish Government's commitment to align with EU law, where appropriate, could mean potentially opting into the same divergences trajectory as Northern Ireland under the protocol. John Thompsons and Sons, a Belfast-based business, said, "The challenge for Scotland is how do we follow EU regulations when we are under the UK single market rules?" During a visit to Brussels in June, we heard first-hand of the EU's concerns for the integrity of the single market, whether divergence could impact safeguarding in the public in areas such as animal health or food safety. Which brings me to the retained EU law bill. I won't say too much about that here, given that we are taking evidence on the legislative consent memorandum next week in our committee. But to quote the Welsh Government, any proposals to deregulate in a way that could reduce the important social and environmental protections and high product standards that consumers and workers in Wales have come to expect are not acceptable. Clearly, there is a substantive difference between the UK Government and the devolved Scottish and Welsh Governments. And this raises questions concerning the capacity of the UK to potentially accommodate 4 different regulatory environments within a cohesive internal market while complying with international agreements. Whether existing institutional mechanisms are sufficient to resolve differences or disputes between the 4 governments, and how devolution should evolve to address these. Presiding Officer, if I could turn to the Sewell Convention. The Sewell Convention will be the mechanism for obtaining the consent of a devolved legislature where the UK Parliament intends to pass primary legislation in a devolved area. Sewell Convention established that the UK Parliament would, quote, not normally legislate in areas that are devolved without the agreement of the devolved institutions. The Institute for Government observed that prior to 2018, consent had been withheld by one or other of the devolved legislatures on just 9 occasions, and in Scotland's case, only once. And that the UK Parliament had never passed legislation without consent when the relevant provisions fell within the scope of Sewell. Since 2018, there have been 6 Brexit-related bills passed at Westminster without the consent of this Parliament. Dr Chris McCorkindale, the committee's adviser, noted that pre-Brexit the Convention was understood to have both a policy and constitutional arm, was respected as a constitutional rule that protected devolved autonomy and facilitated shared government, that any decision to withhold consent was the exception rather than the rule, and legislation in devolved areas would only be made where it was felt necessary on the part of the UK Government or invited by the Scottish Government. In Professor Nicola McEwen's view, the paradox of the Sewell Convention is that it only functioned as a principle and process that fostered culture and cooperation as long as its limits were left untested. Presiding Officer, we believe that there is clearly a need for public debate about these issues, and our committee has lodged a call for evidence to encourage businesses and civic society and the wider public to join that debate. So I welcome this debate this afternoon, Presiding Officer, and I move the motion in my name.